Thanks, Renee, of course, for the very, very kind invitation. I'm delighted to join you all the way from Tuesday evening in Newfoundland. So I have a little glass of wine, if that's okay. I know it's quite early in the morning on a whole different day for you. So thanks, Renee, and to the center for inviting me. And of course, before I start, I'd also like to take a moment to acknowledge the land on which I find myself today, which comprises the traditional territories of diverse Indigenous groups, including the Beothuk, the Mi'kmaq, the Innu, and the Inuit of the province of Newfoundland and Labrador, where I am currently hiding out away as far as possible from Toronto for the remainder of the pandemic. And I certainly hope that today this finds you and your families healthy and doing as well as can be expected during these very strange days. So I'm particularly grateful for this opportunity because it's provided me with a gentle nudge at the end of our teaching term here to get back to work that has been kind of cryogenically frozen since the challenges wrought by the virus and since I gave birth to twins and enjoyed a very strange pandemic maternity leave. And as it turns out, some exciting questions have opened up in the context of the Canadian law of sexual consent in this time. And so what I'm going to do today, I think, is a little, let's say, experimental and tentative. And in that vein, I hope that you'll bear with me and also assist me in working out the argument that I think I want to make here. So I've resisted, as I said to Renee, the temptation to start with a bunch of slides. I do have a few visuals towards the end of the presentation, but until then, it'll just be me. So the talk is titled Against Consent, and that's really capturing sort of my general attitude toward the idea that consent does something meaningful and certainly something essential from the perspective of governing the way that we do sex in society in general, and certainly in the, let's say, the Anglo-Western legal sphere. My basic argument today is that the law of sexual consent works to police, surveil, discipline, constrain, monitor, and otherwise produce what we understand socially and culturally as normatively good sex. So in other words, sexual assault law affirmatively tells us not just what kinds of sex constitute criminal sex, so sexual assault or rape, depending on your jurisdiction, but also what kinds of sex we, particularly women, should be pursuing. It's well accepted that legal and social categories co-produce one another. And so to use the language of science and technology studies, here, Sheila Jasanoff, socio-technical formations loop back to change the very terms in which we human beings think about ourselves and our positions in the world. But curiously, I think too little attention has been paid to the ways in which the highly technical vocabulary of the law of consent loops back to instruct us on our sexuality. In other words, how the line between just sex and criminal sex actually works to constitute what we understand and pursue as politically valuable sex. We seem to think that we can judge what sorts of sex are bad for women without also affirmatively telling women what sorts of sex are good for them and for society. And all of this happens allegedly through the process of giving voice to women's lived experiences of their sexual harms and traumas. And so, as Catharine MacKinnon wrote now nearly 40 years ago, the struggle for women's sexuality is bound up with, quote, a methodological expression of women's situation, which is a new process of theorizing and a new form of theory, whose project is to uncover and claim as valid the experience of women, the major content of which is a devalidation of women's experience. Of course, MacKinnon herself well understood that consent as a concept was woefully insufficient to secure either legal or moral equality in the context of what she understood as seamless patriarchal domination of men over women, which domination was itself eroticized. And so the force of the point of view of male dominance is, quote, exercised as consent, its authority as participation, its supremacy as the paradigm of order, its control as the definition of legitimacy. Against this background, it makes perfect sense that MacKinnon would turn to the realm of international criminal law to institutionalize her deep skepticism of consent. And so at the International Criminal Court, for example, consent to sex in a, quote, coercive environment is vitiated, rendering arguably all sex within the context of armed conflict or widespread and systematic human rights abuses ipso facto criminal. Taking a dominance feminist approach to criminal law in a world of systemic male domination offers a least bad option for many. In other words, affirmative consent. This approach has taken hold within Canadian criminal law. And so I'm obviously not expecting anyone to know much about that. So as a brief primer, unlike Australia, Canada has a federal criminal code, which does not distinguish between the crimes of sexual assault and rape. Instead, all touching of a sexual nature in the absence of consent is considered sexual assault. The presence or absence of consent is determined by looking to the complainant's subjective state of mind at the time of the alleged assault. Consent cannot be implied by silence or conduct, and it is the responsibility of the accused to ascertain whether the complainant is consenting to the sexual touching in situations where consent is ambiguous to the accused. The accused can claim an honestly held but mistaken belief in consent in order to show that they didn't know that the complainant was not consenting. But in order to do so, they must demonstrate that they took reasonable steps to determine whether the complainant was actually consenting. This can include evidence of the complainant's words or conduct. And the basic idea is that the complainant actually communicated consent. If the complainant communicates lack of consent to continue activity, the accused must then show that they believed consent to have been reestablished before continuing the sexual touching. So it's a really quite a firmly affirmative consent-based jurisdiction here in Canada. So since the canonical and controlling case of Unwanted in 1999 at the Supreme Court of Canada, the case law, of course, has continued to develop. In the landmark case of J.A. from 2011, the Supreme Court controversially ruled that in order to fulfill the requirement that consent be active and ongoing, the complainant is not permitted to consent to activity prior to when it actually takes place. So in that particular case, notwithstanding the victim's testimony that she actually consented to sexual activity that took place when she was unconscious, so this is an erotic asphyxiation case, the court found that the actus reus, meaning the absence of consent, was fulfilled. In 2019, in Barton, the court found that, quote, consent means that the complainant had affirmatively communicated by words or conduct her actual agreement to engage in the activity with the accused. And in Goldfinch of the same year, the court stated that, quote, today, not only does no mean no, but only yes means yes. Nothing less than positive affirmation is required. So implicit in the affirmative consent model is the idea that only wanted sex that is communicated as such is deserving of state protection in the form of non-intervention through the criminal law. So ensuring that only affirmatively wanted sex is legal sex is, for many feminists, the best and perhaps only way to ensure that women's sexual autonomy, equality, and dignity are adequately protected. It's going to be outside the scope of this talk to address the related but crucial question of how to handle wanted but dangerous sex. So my project here, I think, looks to show how the law frames consent to quote unquote ordinary sex in order to unpack how it smuggles in particular political ideas about normative sexual behavior, reasonable expectations, and ultimately questions of risk. So stated somewhat differently, I think that the most basic question about consent to sexual activity gives the law quite a bit of room to effectively adjudicate, though it never says it's doing this, the relationship between pleasure and danger. And it does so, I think, in a sexually conservative direction. So as I've already noted, in JA, the Supreme Court held that it's not possible to consent to sex in advance. In January of this year, the Supreme Court granted leave to appeal in a case that raises the flip side of that question. In other words, it asks, is it possible to put limiting conditions on consent such that, notwithstanding consent in the moment of sexual activity, that consent could be vitiated by failure to fulfill the conditions? And so this is the case of Kirkpatrick, which is on its way up to the court right now. So in Kirkpatrick, the complainant and the accused met on an online dating site. The complainant testified that in advance of their first sexual encounter, she told the accused that she would not agree to have sex without a condom. The accused denied that this conversation ever took place. A few days later, when they met up and had sex, the complainant asked the accused if he had a condom and indicated that she had one if he did not. She testified that he rolled over to his bedside table, put on his condom, and that they had sex. He showed her, after they were done, the used condom. Later that night, the accused woke up aroused, rolled over to the same bedside table, and then they had sex again. She testified that she did not hear or see a condom this time, and that she did not repeat her original request because she, quote, assumed that he would use a condom. She testified that she would never have agreed to the second sexual encounter if she knew that he was not wearing a condom. And there's no evidence in this case that the accused took any steps to deceive the complainant about his not wearing a condom. So the question was whether condom use went to the essence of consent to sexual activity, such that not wearing a condom would vitiate the complainant's consent in this case. At the Court of Appeal, the judges were split, with the majority holding that, quote, the common sense proposition that sexual intercourse with a condom is a different sexual activity from sexual intercourse without a condom meant that the failure of the accused to adhere to the limits on sexual activity that had been set by the complainant days in advance was enough to vitiate consent to the second act of intercourse. Because there was no evidence of fraud indicating that the accused tricked or otherwise coerced the complainant into consenting to the second act of intercourse, the court had to find that she had not agreed to condomless sex, because to hold otherwise would, quote, offer no protection to a person who sets limits on the conditions of sexual activity if their partner simply chose to ignore those limits. Oddly, the court reads the two instances of sexual intercourse and the alleged conversation about the complainant's condom requirements, which took place some days previous, as part of a continuous interaction where the complainant's stated condition on consent could be read forward to encompass sexual activity that took place at some point in the future, and where there was no obligation on her to reiterate her condition during each sexual act. In other words, in this case, we can conclude that not only was there an obligation on the accused to take steps to ascertain that she was consenting to the second act of intercourse, but also whether she had relinquished or changed her mind as to the conditions that she had previously set on her consent. So feminist commentators in favor of this, let's call it collateral or conditional limits approach to defining what counts as the sexual activity in question for the purposes of consent. They argue that it's necessary to ensure women's access to full sexual autonomy. So Gattel and Grant, for example, write that, quote, "The choice around whether to use a condom is fundamentally connected to the degree of intimacy one is willing to share with a particular sexual partner." As obvious sounding as this observation is, it's made within the broader context of a supposedly growing culture of, quote, condom use resistance, particularly in the context of casual sex between strangers who meet on dating apps. So in this context, Kirkpatrick is not a standalone case, but sits among a string of cases dealing with condom use in the course of online hookups between strangers. I argue that a sexually conservative attitude toward the kinds of sex that women have and perhaps should have can be detected in these kinds of cases. Another example is the case of R.V. Rivera, decided by the Ontario Superior Court of Justice in 2019. The facts of Rivera are similar, with the complainant and the accused meeting on a dating app, I think it was Plenty of Fish, and agreeing to meet up for sex. The complainant texted the accused, setting out the conditions for their encounter. The first was that, quote, "no means no." And the second was that condoms were her form of birth control and that he must wear one. They actually met up for their first encounter and only encounter about 2 days, I think, after this text exchange. Their testimony diverged at the point where the complainant said that she asked the accused to put on a condom, and he said, "it will be okay, I'm clean," and proceeded to penetrate her without wearing a condom. The accused testified that he agreed to her condom rule in advance of their encounter, but that when he was in the course of removing the condom from its package prior to intercourse, he asked her if it would be okay not to wear a condom, and that she agreed as long as he did not ejaculate inside of her. His evidence was that they proceeded to have intercourse and then that he masturbated himself to ejaculate outside of her body. The accused was found to have lied to the police about some elements of the encounter in the course of the investigation, and the judge accordingly found his credibility to be wanting and accepted the testimony of the complainant. I don't wish to suggest that the judge should have accepted the accused's version of events, but I do want to make two observations. One about prior consent to sexual activity, and another about the underlying normative assumptions that contributed to the judge's reasoning. So first, the judge found that sex without a condom is a qualitatively different act than sex with a condom, and the complainant's consent was withdrawn when Mr. Rivera penetrated her without a condom without her overt agreement. Of course, to the extent that the judge accepted the complainant's testimony that she reiterated her requirement for a condom at the time of intercourse and the accused proceeded anyway, this seems to me to be clearly correct. The reasoning goes wrong, however, when the judge uses assumptions, I think some might say myths, about reasonable behavior during casual encounters in order to shore up the complainant's worthiness of belief. So the judge writes that she believes the complainant did not agree to sex without a condom because this conclusion, quote, is consistent with her two rules, And it is improbable that she would have risked pregnancy by agreeing to sex without a condom, particularly with a stranger. Here we see, I think, that the complainant's prior consent is used to shape inferences about what actually happened in the moment of the sexual encounter, which, as I noted, was some days later. The conditions that the complainant put on a hypothetical encounter days in advance should, I think, have no bearing on what actually happened during the encounter in question. Moreover, the inference that the complainant would have been less likely to agree to condomless sex with a stranger than with a sexual partner who was known to her is completely unfounded and is, I think, rooted in sexually conservative attitudes, masquerading here as protection of sexual autonomy and dignitary interests. So certainly, we should all have the legally sanctioned capacity to decide to have sex on our own terms. Crucially, however, these terms often change, sometimes quite quickly. And so it's not unreasonable to think that a woman could decide in the moment of an actual sexual encounter to jettison her rule that she always uses condoms, quite apart from the complainant's actual testimony that was accepted by the judge. The judge went on to make generalized statements about the nature of sexual activity, effectively deploying her own set of assumptions about sexual behavior to buttress the complainant's version of events. So the judge writes, quote, "When a condom is used as a form of birth control or to prevent sexually transmitted infections, its use provides participants with a sense of security. The non-use of a condom against a participant's wishes not only usurps that individual's sexual autonomy and right to make decisions about how she, he, they engage in sexual activity, it is an activity against that person's will, fraught with the gamut of emotions resulting from an assault." So part of the problem here, of course, is the assumption A, that we know what we want in advance sexually, and B, that what we want, in other words, what accords with our will, corresponds to a less traumatizing and therefore more pleasurable sexual experience than we would otherwise have had. As I have argued previously elsewhere, however, we don't always know what we want in advance, and this can be especially true with respect to sex. The details, I think, of desire and satisfaction are often discovered and produced in the sexual moment. So rather than a question of individual will, sexual autonomy can be expressed through the interaction of two or more partners. And sex can be a uniquely utopian experience in that the act of sexually relating creates novel ways of being together socially. So Joseph Fischel has taken up this idea in his recent book, Screw Consent. Fischel writes, this is such a good quote that I'm just going to read it in its entirety, so forgive me, but Fischel writes that, quote, "It is simply untrue that enthusiastic consent, or for that matter, any consent, is necessary for a sexual experience to be enjoyable. Teenage Billy or teenage Becky might hesitantly consent to butt sex that turns out to be the best, most mind-blowing sex ever. Becky might even slip a finger in Billy's butt without Billy consenting in advance. And Billy might absolutely, unequivocally love the sensation. We can haphazardly or ambivalently consent to sex that is fantastic and consent fantastically to sex that is resolutely unfun." In Kirkpatrick, the majority directly linked corollary conditions to sexual consent, not only to the need to advance personal sexual autonomy, but also to protect the, quote, "public interest." I don't think it's a coincidence that this line of conditional consent cases that I've described focuses on the rationality of condom use to address casual sex between strangers. So public health and sexuality campaigns that link sexual pleasure to condom use have long been criticized by queer theorists as techniques for disciplining gay male forms of life that find intimacy and enchantment in risky, condomless sex. So as Gauthier and Forsyth note, quote, safer sex is not hot sex, it's pretend sex. The need for the intimacy of actual skin-to-skin contact is primal. Condoms are not just a question of sensitivity, they are a barrier to physical, emotional, and spiritual communion. In Canada, HIV non-disclosure can lead to criminal prosecution for aggravated sexual assault and indeed other crimes, where there is a realistic possibility of transmission of HIV and where the sexual partner would not have consented to the sex if they had known the accused's HIV status. In these cases, non-disclosure is treated as a form of fraud vitiating consent. Condom use in combination with a low viral load shields HIV positive men from prosecution, because it is indeed mostly men that get prosecuted for this, promoting the idea of condoms as a common sense normative approach to mitigating the inherent risks of sexual activity. This attitude has been internalized into a background mythology about the kinds of sex that rational women are likely to agree to engage in, and relatedly, the meaning of sexual autonomy. More utopian, non-normative forms of sexual life and expression are then devalued within the law as worthy of exploration and indeed protection. And so in this context, it's easy to see how the idea that consent is sexy takes root as a didactic priority in society as a whole. So one wonders what other kinds of conditional sexual consent might be generated if the line of reasoning undertaken in Kirkpatrick and Rivera ends up being upheld by the Canadian Supreme Court. So, in other words, when consent extends to not just the what of sexual activity, but also the how, there is a risk, it seems to me, that consent law might fancy itself so capacious as to cannibalize the range of complex, shifting, open-ended meaning-making processes that are involved in sexual activity. So it's at this point that I actually will share my screen for a moment. So this poster is so great. So it's an example of the Safe Sex is Hot Sex campaign that got going in the United States and elsewhere in the early 1990s. That's demonstrating the kind of attitude that Gauthier, Forsyth, and others, of course, object to. I just want to look at this quote from Duncan Kennedy's A Semiotics of Critique here, in particular, the second paragraph. Actually, I'll just minimize it so I can see my notes. But so in other words, looking at this quote from Duncan, I think that something important is lost when we make every act of sexual context processable within what Kennedy calls the cognitive system of sexual consent law. And so Kennedy talks about this idea that processing goes beyond scanning rather and winnowing. If the only categories of sexual relations in the legal system are forced and consensual sex, each with a well-defined, distinct consequence, conviction or acquittal, then the prosecutor must decide whether a given narrative involves one or the other, even if this distinction is foreign to or just ignored by the narrator. So Kennedy continues, this type of cognitive system is structurally closed but cognitively open because it has a fixed set of interpretive categories and only two responses, but can process any narrative. So the point is that when we engage in sexual activity, we are not necessarily doing so from the perspective of ensuring our autonomy. So indeed, we might not care very much about our autonomy in the moment. We might not be thinking in terms of coercion versus freedom. We might care about pleasure, about risk, about pushing boundaries or experimenting with forms of being outside our bodies, where to be outside ourselves does not necessarily mean that we are dissociating or having a trauma-based physiological response. It could be this, of course, but it could also be something else. And so my question is, what if we flip the script in Kirkpatrick? This is where the talk gets a little more tentative. So imagine we're faced with a situation when a man meets a woman on Tinder, for example, and agrees to have sex with her if and only if she is on birth control. What of the dignitary harm associated with his unwillingly, or perhaps at least unenthusiastically, impregnating a stranger? Is unprotected sex with a woman on birth control a qualitatively different act than sex with a woman who is on the pill? And how much information must be known in advance about each party before sex can be consensual? For example, is it necessary to know the identity of your sexual partner? Is anonymous sex in the park permissible? Perhaps sex using a glory hole? A large part, I think, of what is missed by the focus on consent is the relationship between sexual pleasure and the unknown, the possibility of risk, the possibility that things might not go as planned or as we think they should, or as we have communicated they should. Consent comes in to close the openness of Kennedy's processor here. Safety is sexy. Consent ensures safety. Therefore, consent is sexy. What else could one possibly want? And so I think I'll end just by turning your minds very briefly to the Pinterest site from the Dalhousie residence life, whatever institution at that university, which just shows a plethora of didactic public education campaigns, right, that combine legal language around consent with public education on why consent is important, and in particular because it's sexy, or at least because we should think it's sexy. I have a few things that maybe I'm very obsessed with with the desire to outlaw or prohibit certain kinds of discrete sexual practices, in particular, the act of sexual choking. And so I think I'll end on this point. And I'm obsessed with this in part because it's caused such a huge division within the feminist community, with many feminists arguing that choking is inherently violent, at least conceptually, and is therefore not amenable to being consented to in the way that we ordinarily think about consent, and especially if we're wanting to reframe consent in affirmative or enthusiastic terms. And so in Canada, at least, sexual activity rather that causes serious bodily harm would in all likelihood constitute assault, but the question of risky sex is less certain. It's a bit of a gray area at the moment. And so I've been tracking the way in which consent discourse, especially the industry of public education around consent that I've just alluded to with those posters. I've been tracking the way that the Me Too, whatever it is, movement or whatever, has really ramped up consent thinking and consent discourse kind of everywhere, right? And this started, I mean, it probably started a lot of places, but one place was with the sexual assault allegations that were made against former New York State Attorney General Eric Schneiderman. And so this is a bit ironic. Several former girlfriends of his told the New Yorker, for example, that he had been repeatedly verbally and physically abusive to them during their relationships, which included physical assault during and also outside of sexual encounters. And so non-consensual choking during sex was a theme in these allegations, which were, of course, particularly alarming because of Schneiderman's own history, positioning himself as a champion of Me Too, including the fact that he had sponsored the 2010 Strangulation Prevention Act, which created the standalone offenses of criminal obstruction of breathing or blood circulation and just, quote, strangulation. One of his accusers was quoted as saying, "You cannot be a champion of women when you are hitting them and choking them in bed and saying to them, you're a fucking whore." So post-Schneiderman, feminists emerged in force, not only against non-consensual strangulation, but indeed against the generalized sexual practice of just choking during sex. So Kate Mann, for example, wrote in the New York Times that, quote, acts of strangulation, and so she refused to consensual choking as strangulation repeatedly. Acts of strangulation are highly harmful in their own right. She went on to say that, quote, the overarching message when a man assaults a woman in this way is deeply patriarchal and misogynistic. He has shown her what he is prepared to do to enforce his will if she defies him, this being in effect the most basic form of patriarchal governance. So I want to be clear at this point that although I have many concerns with the validity, as I've said, of consent as an organizing category, for my purposes here, I'm not concerned with the question of clearly non-consensual strangulation, but I want to talk about the very common practice of sexual choking to highlight the limitations of the consent coercion paradigm that the law of sexual assault relies on. So I think that questioning this binary is particularly important, as I've said, since Me Too has focused increasingly on ramping up consent discourse in general, everywhere, all the time. So the feminist assault on choking plays directly into the liberal legalist system processor that Kennedy talks about, because it tells us, regardless of what the parties involved may believe about what they're doing, that such allegedly inherently risky practices are incapable of being consented to. So in the language of liberal humanism, they're cruel in a sense that we are unwilling to legally accommodate. Sexual activities such as choking can combine fear with pleasure and danger with the erotic. The consent coercion framework does not allow us to compute one side of this equation, and I think that's a big problem. Liberal legalism, based as it is on the liberalism of fear, only permits cruelty when it has been whitewashed in consent. So in other words, liberal legalism lies to us about the nature of sex. It tells us that good sex is consented to sex, thereby making a value judgment about the spaces in between that it just doesn't have the political authority to make. So I've most certainly used up my time at this point. Thanks so much, and I'll leave it there and look forward to observations and questions and discussion.
Thanks so much, Heidi. If people would like to turn their cameras on now, they can. If you'd like to kind of be part of the discussion, but also you don't have to. I'm going to open it up now for questions. So if anyone has a question, please feel free to. Oh, Kate has a question. Can you? I'm just wondering if you can turn on your own microphone because we're not in a webinar. Can you, Kate? Yes.
Yeah. Thanks, Renee. Thanks very much, Heidi. It was really interesting. I have a question that might a bit of a long, perhaps slightly garbled question or / comment on temporality. That's what I wanted to ask you about. So I understand the concerns that you're expressing, which I totally agree with, about this sort of process by which it seems that the court is reading normative concerns about sex and then imposing those normative assumptions onto consent. And also, I think, as you explained, sort of mobilizing those normative ideas about sex to draw inferences about things like the credibility of witnesses, the evidence by witnesses and so on. But it seems to me there's maybe also something else slightly different going on that's not just about normative assumptions, but that's about temporality. And in particular, it seems like in those cases that you described, like Kirkpatrick, I think, and JA, there's this process of continuing in conditional consent, I think you called it, over time, and this sort of stretching out of time, this process of allowing us to go back several days, perhaps, or maybe even longer. In theory, that could happen even weeks in time, and seeing that as a kind of continual process of consent. And I don't think, I guess my gut feeling is that that's not strictly about the kind of normative assumptions that you were talking about. This is a different process taking place about the mobilization of a particular idea about temporality and allowing these ideas about time to be brought in. I hope that makes sense so far. And so I guess my question for you is, I'm interested to know whether you have a view about why this process of allowing us to stretch time out, why that has happened. Is it something like a workaround that the court has entered into because there are such problems with prosecuting sexual offences? Is it something else? I'm just kind of interested in what might be going on there with this temporal dimension that's crept into the law.
Yeah, that's so interesting. I don't know, Renee, do you want to collect a few comments? Would that be the way to go, or how do you want to?
Oh, I think we can just go back and forth if you like. So you can respond to Kate, and then potentially we can move to the next question or next comment, if that works for you, Heidi.
Yeah, absolutely. So I wish I had an answer. I mean, so I think this is a great question, and I need to do. So I'm very happy you raised it, because it clearly signals like there's a lot of thought that's been done on legal temporalities, like not to mention the relationship to geographies, right? But legal temporalities in general. And so connecting that question of time and like elasticity and stretchiness and what that does for us, I think is clearly crucial here. And I've only just gestured to it, but you've honed in on that, which is very, very helpful. So I certainly need to do more thinking on that. I do want, I think, so this is like probably wrong, but my intuition like at this point would be to say something like, at least in the cases I've read so far, that the court seems to want to give like credence or whatever. We want to give, here it's been women's assertions of their self-understanding of their own sexuality, like force in the moment. And where clearly, what one says, I don't know, at 2 a.m. on Tinder, it could be quite different from what you do, a week later or 6, as you know, you're quite right. This could happen like 6 months or a year later. And to what extent should we be bound by assertions of wantedness or desire that are almost completely decontextualized from what happens then in the future? I mean, it's ironic because a lot of the sort of pushback, Renee very helpfully shared with me this like milkshake video that's been going around Australia, I guess. And then some of the feminist reaction to that, which has said, well, consent is really easy. It's not that complicated. What's the fuss? Whatever. Why are we talking about it like it's a milkshake? Consent is continuous and ongoing, needs to be continually reiterated. But it seems right that there's like an obvious tension between the idea that consent to each sexual activity should at the very least be ongoing and maybe needs to be renewed depending on what's going on. There's a tension with that and kind of wanting to give some kind of legal force, roughly, right, to almost a contractual statement in a text or whatever. So I'm not sure. Those are just some initial thoughts, but thanks for raising temporality. I need to think more about that.
Nicole has just put a message in the chat, which I'm happy to read out if you don't want to, Nicole. just says, I'm interested in the absence of the kink community in this discourse so far. The kink community and their non-normative ideas of sexual pleasure having originated the idea of active consent and placing emphasis on doing consent work ahead of time. Sorry, I just did something weird. Ahead of time and in detail, and the emphasis that the kink community puts on the responsibility of doing the work of knowing what one wants in sex, even at the cost of the enjoyability of spontaneity.
That's a really important question.
Just kind of also, I was going to also say, which is a kind of not just to add on to that, just about how some of your thinking, you know, might kind of translate or also be interested in inform our thinking beyond kind of rationalities of birth control and condom kind of non-heteronormative sexual relationships. So that's also kind of related to what Nicole's bringing up there, I think.
Yeah. So those are both really important points. Sorry, I'm just taking notes. Yeah, so that's a common this idea about like, why aren't we turning to the kink community and giving them credit for having done the work, as it were, or some of this essential groundwork on consent, like long before anything happened with Me Too, which is certainly the case. So that comes up a lot. I think it's really important. Obviously, the larger work will have to incorporate that. I think one thing that one small comment that I would make would be to say that I think within the kink community, if such a thing exists, right, as a cohesive community, I think there are divergences around that idea, and that there are different degrees of intensity in kink play, and that not all of them correspond to this idea of parsing out consent in advance, as you say, at the expense potentially of pleasure. I think some do, and I certainly think that there's some divergence from that position. And so I personally find, well, several folks is obviously work valuable, but Khan's work here, I think is really important. But I think it also comes up certainly in Fischl's work as well. Yeah, so Renee, great. So rationalities on birth control and condom use outside of the heterosexual context, totally key. I want to be able to say more in this project about the relationship to HIV non-disclosure and sort of the gay male community and sort of what's going on. So a bit of the more background that I didn't have space necessarily to put into this talk is that the Kirkpatrick and Rivera cases and others in this line are responding to a case called Hutchinson, which was factually a little bit different in that it was a case where a man was like poking holes in condoms like over time to try and get his partner pregnant against her expressed will. And so the question there was whether she had consented to the sexual activity or whether there was fraud vitiating consent. And that's kind of the case that's caused this big problem, because the court wanted to sort of divorce the question of contraception and sexually transmitted infections from the question of consent, in part because there was intervention from HIV advocacy groups saying, if you're going to allow conditions to be put on the understanding of sexual activity simpliciter, then that could look like non-disclosure or disclosure of HIV status as a condition, which would then hamper all of the activist work that had been done around tempering the impact of prosecution for HIV non-disclosure. So there's kind of this background story that really intensely implicates that community and set of interests as well. And certainly that would have to be brought to the fore more.
I think I can see here that Heather, we've got two more questions. Heather, did you want to ask yours, and then Jenny?
Yeah, sure. My question was around the temporality issue, and I guess that question that Kate rose and your comments around the relationship between healthy sex and consensual sex. And so it doesn't surprise me, for example, that a deal made around ongoing use of a condom or even contraceptive might be seen as ongoing consent, whereas in a violent relationship, for example, where there was previously consent between intimate partners, a court would say that consent isn't ongoing. So they're making value judgments here, I think you're pointing to. And I wonder, really your whole project, in a sense, points to the whole question, the bigger question about the role of law in kind of medical health, and the limitations on people's practices, and the role of research about health and how that should inform the law. And I think that's really interesting, because I think that it has been a subtext of law perhaps forever. And so it's that balance between health and autonomy that law tries to, I don't know, could you speak to that? I think that's kind of what it's raising for me.
Yeah, that's so interesting. I wish I'm not sure entirely what to say. I mean, I think that's obviously totally true and a really crucial observation. So one thing, yeah, I guess my immediate reaction would be like the way in which ideas of mental health and well-being come into this as well. So not just, so I think obviously physical health is, and reproductive access to reproductive care and all of that isn't implicated, but the degree to which certain ideas about trauma and traumatization get taken for granted in the discourse and in the case law, so that we're given a picture, particularly in Rivera, of, well, actually in both cases, of the intense psychological harm and stress and counseling that these women needed after their assaults, which of course is only a partial picture, of the very varied reactions that all people have to different kinds of assaults. And I think, so Jeannie Suk Gerson's work on trauma is really interesting and needs to be brought in as well. But certainly, and this is partly what happened in the Hutchinson case that I just referenced. So actually what they did there is the court decided the case as a case of fraud, where, so fraud requires a deprivation. Usually that deprivation is understood in terms of serious bodily harm, and the court expanded deprivation there to include serious psychological harm, which ironically ended up basically expanding then the range of cases that could be, the range of liability that could be brought for folks who don't disclose like HIV status. So it becomes this whole like vicious circle, but yeah, so those are just initial thoughts, but that's obviously a crucial point.
I think we have time for maybe one more question, and that was from Jenny Walsh, if you wanted to unmute.
Hi, and thanks, Rebecca. I'm a sex educator, and so I work with children and teens and parents and teachers. And I guess I want to apply Heather's question to the issue of education, and how using a legal construct to teach, essentially what I want to teach is positive sexuality, to teach about consensual sex has been really problematic, because it has been dominated by teaching about the law to 13 or 14-year-olds, and then of course they find themselves completely confused in the real world about their own uncertainty about what they want to have a go at. And of course that is the essential to adolescent sexuality, right, is not knowing what you want to do and having a little go. So I guess that we are sort of trying to correct inheriting a legal construct to a human experience. And I would be interested to know if you've seen good stuff, good education, and how we might even get away a little bit from the notion of teaching enthusiastic consent, and if that's a problem.
If enthusiastic consent is a problem. Yeah, I think it is.
Yeah.
So you would, I mean, you're the expert here. I just think you're right. I think using, and this has come up, Percy, which is my son's name. So it's great. I love meeting Percy's. Has also mentioned this, right? That there are discourses that happen outside the law. And my point of that I only touched on, I think, in the talk was to say that these discourses are co-produced and that can cause deep problems. And I think what I've seen from the education, and I actually started like buying up children's books when I'd see them like on, on consent, and they're all, I mean, again, you're absolutely the expert in this, not me at all, but from what I've seen, it's like very, very problematic and simplistic and weird. And just, I mean, I don't know, I just don't, it's not my experience, as you said, that maps on to what folks actually do. And maybe, I mean, this would be a question for you. I'd just love to hear more, like whether this emphasis on kind of knowing what you want and also then kind of enthusiastically expressing it, whether that creates anxiety and trepidation and maybe even more uncertainty, because the realm for, and I'm just kind of just talking here, but that the realm for like positive experimentation where consequences aren't like knocking on the door is perhaps less present today than it may have been in the past. I'm not sure.
Well, of course, I'm in furious agreement with you. And I think it's so related to trying to simplify difficult concepts for teachers to teach, and they get so little professional development on this issue. And so what it translates to in a classroom is a thing on the law, an overview of the law, and then the tea and consent video, which I'm sure it is very enthusiastically embraced in Canada as well. So sorry, wherever you are.
No, I'm in Canada.
yeah, that's right, good. I had a little freak out then. But the other thing I would say is that I was offering comment. So the national curriculum is currently being reviewed, and consent ed sits in the health and PE subject area. And so there was even enthusiasm about using the term consent for primary school sexuality education, which, is wrong, but I can see that is going to happen. So, yeah, and again, talking to people, parents of toddlers, where they're, asking their children permission to change their nappies and so on and all of that sort of thing. And that, yeah. And so just that, it's mushrooming out and out, so I don't know if that answers it, but it's having an effect across a lot of areas.
Yeah,
sorry, I was just going to say I might have to jump in there. We've just reached 11, and so I think I'll have to start wrapping up the seminar. Did you want to say one final thing?
I'm so sorry. I was just so excited by this intervention because I think it's so spot on. I was going to say I have twin 10-month-olds, and like one assigned a girl and one assigned a boy, and like even this rolls into the discourse of toxic masculinity and like what mothers are supposed to do as parents, and it's just this like huge mushroom. But thanks for that. That's really great. Renee, are you able to maybe just take a shot of the comments in the chat so that I could look at those later on as well?
Yes.
Or I guess I could do that actually.
No, it actually comes to me in a text. A kind of text file, but I've just cut and pasted as well, which I can send through to you. But yes, thank you everyone for joining us today. Thank you so much, Heidi, for that presentation. They were great questions and a really great discussion actually. So thanks everyone for sticking around and making it such a great seminar. For those who are interested, our next seminar is on May 19th. We have Dr. Finn McKay speaking on the UK gender wars and lesbian identity. I do hope you'll come along. Once again, thank you, Heidi, and I'll say goodbye until next month.
Thank you so much, everyone.
Bye.